Okay, before I hand over to Alison, who's going to do our kind of chamber update, and then Alison will hand over to Liam, I'm just going to do a little bit of an intro from our sponsors at the Glen Turret. The Glen Turret have taken out one of our digital takeovers and kindly sponsored 2 of our webinars. So for those of you who don't know, the Glen Turret Distillery is Scotland's oldest working distillery and welcomes visitors for excellent distillery tours, giving an up-close view on traditional whisky making. The Glen Turret is based in Crieff, Perthshire, and their gift shop offers a fantastic range of single malts that make dram fine gifts for family, friends, or even to treat yourself. It's set in the beautiful Perthshire countryside and is Scotland's oldest working distillery, and a truly unique whisky experience. Their malt whisky is still handcrafted today as it was over 2 centuries ago, using the only remaining hand-operated mash tun in Scotland. Drawing on the area's plentiful natural resources, whisky is made by hand and heart, and visitors will have an experience the traditional handmade distilling process that have been used to craft the whiskies at the Glen Turret Distillery for generations. So if you're looking for a wee gift for Christmas time or something to treat yourself with, then certainly get in touch with the guys at the Glen Turret, and I'm sure they would be happy to help. We will pop their website address in the chat, so have a look at that later tonight. Okay, I'm going to hand over to Alison now, who will do our chamber update.
Thank you, Sarah. Just a really sort of quite a short update from me. We're here to kind of hear about Brexit, and those of you that may not have been on the others in the series, this is the 3rd in our series of Brexit related webinars where we've been looking at recruiting and employing and how Brexit impacts your workforce. And we've also looked at e-commerce and the impact that it's going to have on that. And then of course this evening is all about intellectual property. You know, I'm also have been hearing on the jungle drums, and I may be stealing all Liam's thunder talking about the 28th of December, but it seems like there's plans afoot for the UK and the EU to get together between Christmas and New Year, when we're all, you know, partied out from Christmas in our own households. And you know, we seem to have been talking about Brexit for so long, and lots of businesses are still trying to make sense of how it really impacts on them. But we've been running a kind of a number of webinars focusing on this for a long time, and our international team have been talking to lots of businesses just about some of the practical support, some of the unanswered questions, even at this stage about logistics and some of the other things that do apply to businesses, but just trying to remind everybody that there is a lot of information out there, or there are certainly a lot of pointers to help you kind of look at your own business and how it impacts you. We are continuing to do a lot of webinars, and we will do in the run up to the kind of the Christmas break. And along with British Chambers of Commerce, we have got one of the final kind of Brexit webinars, which is the countdown to change, 30 days to go. So on the 1st of December, you can you get a perspective from British Chambers of Commerce on some of the things that there may still be that you might not have quite thought about when it comes to Brexit. But the Chamber's also doing a lot of work in international markets, helping businesses look at new markets. So we are running a couple of webinars before Christmas looking at doing business in the Netherlands. That's tomorrow evening. But we're also doing one about doing business in Virginia. And the Netherlands connection is very much around circular economy and the kind of the maritime sectors, because Rotterdam as a port and Rotterdam as a circular economy place to do business has got very close synergies to Dundee and to Scotland. Virginia is the home of Alexandria, which is Dundee's twin city, and the wider Alexandria region has got some brilliant similarities and synergies in with Scottish businesses. Amazon has got its second US headquarters there. The kind of the bioscience and tech scene and food and drink and other sectors are really useful in terms of Scottish business looking at that as an entry place into the US market. So lots going on for the Chamber, and we have one of our last virtual DAC 123s happening on the 1st of December as well. So lots of things for you to do before it's time to kind of hang up your kind of pen and pencil before the Christmas break. But Liam, I'm going to stop talking now and come to you. So today's session, we're going to hear from Liam from Thornton's, and then there'll be time for questions at the end. And I'm sure there's always lots of things that will kind of spark ideas. But Liam, you're going to talk to us about intellectual property. So once I can hear you, I'll mute myself and get out of your way.
Okay, thank you very much.
Fab.
Alison, you can hear me okay?
Mm-hmm.
And can you see my slides as well?
Yes, sure can.
Good.
Yeah, fab.
Great. Okay. Thanks very much. What I am going to do is basically just talk you through where we would see potentially the changes and the significant impacts that are likely to arise from Brexit in relation to intellectual property and the things that businesses who have to deal with intellectual assets of whatever sort will have to be aware of during that time. And there are a variety of consequences that flow from elements of that. Some of this will probably be known to you already, but we are now coming to the end of what is the Brexit transition period, which effectively has run from the 31st of January until the end of next month. And that period was provided for under the withdrawal agreement. It was originally supposed to be about 2 years long, but because they took an extra year to negotiate the withdrawal agreement, it's ended up being a relatively short period of time. And the government, although it had the option to extend that period, elected not to do so, and in fact was quite explicit that it intended not to do so in the general election that took place around a year ago. And the transition period that we're currently in, as no doubt a number of you will know, means that effectively, although we are no longer part of the political institutions of the EU, we are effectively still subject to all of its laws, and we also can exercise all our rights during that time as EU citizens to move, to buy and sell goods. We're in the customs union. And so essentially, I think there has been a perception that nothing has particularly changed. And certainly in terms of the management of intellectual property, the flowing of data between the UK and the EU, that would all be correct. But we are obviously going to see that change quite significantly, and that change is going to happen at the end of this calendar year. Now, as Alison pointed out, it is likely, if I were to bet, that some sort of deal will be put in place between now and the end of the year. I'm sure it must be a great delight and pleasure for civil servants to work for the current government, and they'll probably be all the more grateful that they're going to get hauled in between Christmas and New Year to finish it off at the last minute. I mean, in some respects, that is part of the theatre of these negotiations, and whenever the last minute happened to fall, if the deadline had been the 30th of November, there would probably be a load of drama this week and next week getting things finished at that point as well. I think one of the things, though, that it's probably important to bear in mind is that this is essentially different from the situation that we were in around a year ago, when all the pressure was about negotiating the withdrawal agreement. And I do get the impression from a lot of the discussion about this that there is a perception that if we get a deal, everything's going to be fine and there'll really not be very much disruption. And if we don't get a deal, it could all be absolutely terrible. I mean, I think that is correct, and I think it could be a total shambles if there isn't a deal in place. But it's also important to remember that even if there is a deal in place, the shape of that deal has to a large extent been set both by the terms of the withdrawal agreement and also government policy. And the reality is that deal or no deal, lots of things will change at the start of next year. And that's why you're seeing things like the government information campaign about, you know, prepare and get ready. And I mean, it's a perfectly valid and legitimate question, in my view, to say, well, for what and on what terms can we expect to be doing business this time next year? But a lot of areas are going to change, and certainly in what we're seeing in the field of intellectual property and data, which I'm going to talk about, there is relative certainty about what a lot of these changes are likely to be, and the difference between how these things will be governed in the case of a deal and in the case of a no deal are probably not as radically different as people might think. So if we look, just I suppose to be clear at the start, in terms of the IP that we are going to talk about here, and I've mentioned up here the types of IP that we generally get engaged with in this area more, in this local area, that is more than any others, and that tends to be looking at copyright, it tends to be trademarks, geographical indicators and protective devices, and also looking at data management. Obviously there is also a whole body of law relating to patents, and in the pharmaceuticals and biotechnology sector in particular, the patents are a valuable and important asset. They don't tend to be too directly affected by EU law, though, in the way that these other matters are. So that's why I've left them slightly to one side. The centralised patent protection regimes in Europe haven't really got going yet. And that is already quite a fragmented area where you do tend to have to work market by market and country by country. That's not necessarily the case with these other ones, and so that's why I'd like to focus mainly on those and just give a quick recap of what the main legal issues are likely to be in relation to each of them. I'm then going to talk about data, because I think data is one of the things that almost any business is likely to come up against. But one of the things to bear in mind, though, particularly when you're dealing with intellectual property, is that as a lawyer advising in this area, whenever we meet new clients, intellectual property crosses borders. You don't advise clients who meet you and say, I've got this brilliant idea, this brilliant business model, and I'm only really interested in taking it forward in the UK. But by its nature, something that is a compelling idea or a marvelous invention or a brilliant piece of creative work in Scotland is going to have the same potential in lots of other markets. And in particular, in terms of attracting investment, in terms of growing and driving their businesses forward, those businesses will obviously have to have a very close eye on how freely they can trade, how they can develop and grow their markets and grow their products in other territories. So there is an inherently outward-looking and international aspect to a lot of these types of businesses, and businesses for whom these things are essentially core assets, and some of that is going to change quite a bit in the relatively near future. The other thing is that over the years, and we have been in the EU for nearly 50 years now, a lot of EU law has seeped its way into intellectual property. The single market saw quite a lot of harmonisation. In the case of copyright law, for example, it was considered unpalatable to the European Commission that you could have a situation where different countries had different periods of copyright, so something could be in the public domain in one country and copyright protected in another, and so there was some harmonisation of a lot of these things. In some cases, there were certain protections and remedies given at an EU level, which could then be enforced through the European courts, which of course is something that's going to be far less readily available after Brexit, and also the fact that businesses themselves needed to be assured that they could protect and capture their intellectual property for use in more than one country. The other thing, which has been the case for the last 20 years or so, is that almost all the regulation that has applied in the UK in relation to data protection has originated from the EU, initially in the mid-1990s through the Data Protection Directive, and then latterly the General Data Protection Regulation. And the difference between those two concepts is quite important. A lot of European law, which has been incorporated in the UK, has come through the form of directives, and that's effectively where the EU sets the policy and essentially what the law has to achieve, and then the individual member states implement it in a way that works within their own different legal systems. Where they implement regulations like the GDPR, there is a body of regulation which directly applies into every EU member state. It's not up to those governments how they choose to implement it. It doesn't cater for the quirks and niceties of individual legal systems. And so as part of the management of Brexit, a lot of this law is being imported almost automatically en masse into UK law, and will then potentially be subject to change going forward. So over the years, a lot of intellectual property law has been affected by things that have happened at a European level, principally because it's seen as an intrinsic part of the single market, and having different rules about how intellectual assets are protected in one territory versus another is seen as distorting the viability of the internal market. Now, there will be, and there are some issues still to be resolved in the trade negotiations at the moment, because it is very common for a baseline standard of intellectual property protection to be required as a prerequisite for effective trading between different nations. One of the issues that a lot of the Western Hemisphere has in terms of putting in place robust trade agreements with China and certain other territories is the adequacy of their intellectual property laws. And so that isn't necessarily going to change, and we're not going to move from a situation where we effectively are part of this body of European intellectual property management to a situation where we're completely autonomous, because the economic realities are such that it will have to take account of the requirements of other markets and other jurisdictions, and individual businesses as well will be looking to trade and to operate in those different territories, and so we'll also have to have an eye on what is manageable and what can be done in different countries. So once the transition period has ended, and once we're into January 2021, what we will see in relation to intellectual property is that EU law will no longer apply in the sense of being imposed from Brussels, regulated and subject to the jurisdiction of the European Court of Justice. However, those laws will effectively be imported en bloc into the UK legal system, and it is also likely that all the policies and case law and precedent of the European Court will be considered influential in terms of guiding how that means, but the UK courts won't be bound to follow it anymore. So if they want to take their own approach, they can do that. Where there are EU registered rights in relation to things like community designs and perhaps more relevant trademarks, they will effectively be separated, and there will be created, or if you like, branched out of it, a UK comparable right to sit alongside the European one that's already been registered. So if you've applied for and got a European community trademark over something, then as at the 1st of January, you will still have your European community trademark, but it won't cover the UK anymore, and you will have what will be referred to as a comparable UK trademark, which is effectively a UK mark that will be in the same terms. Now, there are some changes around the administration and the processing of those, but that essentially is a snapshot of what will happen on the 1st of January. In terms of data protection laws, the UK's Data Protection Act of 2018 will continue in effect. That law has effectively imported large chunks of GDPR into UK law, leaving aside the fact that GDPR itself has applied directly as part of UK law up until now. And that will apply. The other thing is that GDPR itself, it states that it does apply outside the strict boundaries of the EU itself, and it applies to organisations who are processing personal data in the EU. Now, there are some debates and some arguments among international lawyers about how enforceable a lot of that is. If, for example, you're a US-based business that never goes anywhere near Europe but happens to have some data functions there. But there will be that extraterritorial claim of GDPR. So UK businesses who are processing data in the EU will still have to think about compliance with GDPR and could still be held to account to comply with GDPR. Most of the other bits of privacy law in the UK, such as freedom of information and the like, will not really be affected by this. The extent to which UK law is affected by it may depend on policy decisions that then are taken once the legal systems are effectively separated out from each other. So what I think we're going to see is at the start of January, a lot of these laws will effectively continue, and the vast majority of them will continue to apply, albeit through the UK statutory route rather than directly from Europe. And then in time, there will be the potential for those to diverge. Now, whether that happens quickly or not will remain to be seen. I mean, one of the arguments for Brexit initially was that it would allow the UK to set its own laws in these and lots of other areas. I've not seen lots of examples of specific laws that there's an immediate appetite to change, but there will be the possibility of doing that in the future. So just looking at what some of the key types of intellectual property actually are and how they're likely to be affected by this. Copyright is probably the most practically significant one, because almost every business will own copyrights in its assets. Some will have them as their core focus. If you work in creative industries, if you work in software or app development, or any other kind of media. And actually, copyright is probably the least directly affected by Brexit itself. And principally the reason for that is because copyright law in the UK is principally governed by the Copyright Designs and Patents Act, which is a UK piece of legislation. Copyright generally arises automatically in works that are created. You don't need to go and register them with any particular authority or anything like that. And there is quite a complex suite of international treaties and agreements which most major economies are party to. And they tend to set out a baseline level of copyright protection and certain things that have to be in there, and most of the EEA or the EU member states are parties to those too. So in practice, the UK is already subject to a whole load of international agreements which will effectively regulate and set a baseline level of copyright protection. That said, in future, there is the possibility that laws will deviate. One of the more controversial laws in the EU that's been working its way through recently is the Digital Copyright Directive, and that addresses a number of quite sensitive issues, such as the liability of social media platforms and other operators for content posted by their individual users, and areas where there has potentially been some disagreement between what the UK government's ideal policy would be in some of these areas and what's actually been implemented from the EU. And in those cases, we will start to see the law diverge a bit, and you could find that if you operate across different territories, you have to be aware of that, and particularly in relation to online businesses. If you end up in a situation where you have differential liability for your content in different countries, then that could affect the risk profile of those businesses. That has always been an issue to some extent, although in the main, the key provisions, both, for example, in the EU and the US, have been very similar up till now. So if there is scope for divergence in the law, that might be something that has an impact. But in general, copyright will continue by and large as it has done before. Trademarks will be subject to quite a lot of change. As I mentioned earlier, there is an existing EU regime for the registration of community-wide trademarks. The UK will effectively no longer be part of that going forward. So if you wish to, at the moment, as a business, if you want to protect a brand or a mark, you would have the ability until the end of next month to apply to have that registered as a community trademark, and if that is accepted, then effectively nobody anywhere in the EU would be in a position to use that mark or something confusingly similar to it within the scope of the registered classes of use. After December, that won't be possible anymore unless you apply for them both separately. So you would need to apply for a UK mark, and you would need to apply for an EU mark to cover the other 27 countries of the EU. Now, a lot of businesses may not necessarily choose to do that. It may influence whether they would effectively seek to obtain their UK mark first, or simply obtain a UK mark. At the moment, roughly the cost of getting a EU-wide trademark is roughly about 2 to 3 times the cost of getting a UK one. On its own, there is probably a slightly greater risk of challenge and complication in the EU case, because you are effectively asking to have your mark protected in a market that's about 6 times the size of the UK. So there's more likelihood that somebody might object or raise concerns about that. So it'll be interesting to see how that affects organisations. It's also going to have an impact quite significantly on the administration of trademarks. So, for example, within Thornton's at the moment, we have a trademark agency, we have a qualified trademark attorney who works in this area. We are in a position to file and submit applications on behalf of our clients in the UK and in the EU. Going forward, we will be, the agreed position is going to be, we'll be able to file applications in the EU, but we will not be able to represent clients before the EU IPO. So if somebody raises an objection, or if there's anything that requires any kind of advocacy or representation, we will have to arrange for somebody trading in the EU to represent our client and do that for us. We can't do it ourselves. The law won't have changed. There'll be no change in our expertise or ability to offer that service. In all likelihood, the EU IPO personnel will be equally capable of dealing with us, but will not be allowed to do it anymore. And the flip side of that is the same is going to happen in the UK. So the UK IPO will only deal with UK registered trademark attorneys. So that will have an effect on the practicalities of how we go about registering and protecting marks. It's not that different to the way it currently operates in the US, where the US Patent Office will only liaise with US registered trademark attorneys, and it's just a practical example of the sort of protectionism that's coming in lots of different areas in relation to Brexit, and it is introducing something which certainly in the short term is potentially going to be a bit of an administrative headache for people that work in these areas. There are some transitional provisions so that live applications or ongoing matters that are being dealt with will be seen through to a conclusion. So they're not literally going to put the phone down to us straight away. But in the long term, we will have to develop international partnerships so that we can continue to service UK businesses in that way, working through the EU. The other thing is that there are quite a lot of areas in trademark law where there is potentially scope for the law to diverge in future. A lot of the significant cases in trademark law in the last 20 years or so have ended up in the European Court because trademark rules have very largely been harmonised. The existing, although the Trademarks Act 1994 is a UK piece of legislation, it's very derivative of EU laws, and a lot of the provisions of UK trademark law have been ruled on by the European Court over the years. So quite important things like the extent to which bidding on pay-per-click search terms might constitute trademark infringement, the extent to which you might be able to trademark a geographic term or place. Those are all points where the key decisions have been made in Europe up till now, and going forward, those landmark legal judgments will be, I suppose, persuasive rather than binding on UK courts, and there might be scope for the law to diverge in various different areas. And brand owners who trade in the EU will have to look at whether they need to maintain a separate register of UK trademarks versus EU marks and split their trademark families out in that way. And while a lot of the changes in that area are administrative, they're possibly in the short term some of the most cumbersome ones for businesses to deal with just because of the scale of all of that. The other one that's sometimes referred to as an intellectual property right are rules around geographical indicators. Scotland actually does not too badly with these, and we've got quite a few of them in place. I could have put a picture of an Arbroath Smoky up there, which might have had a bit more local relevance, but I had some of this from a breakfast on Sunday, so it was resonating a bit more immediately. And Stornoway Black Pudding is one of these, and the effect of a geographical indicator is that you can only call something Stornoway Black Pudding if that's where it's made. There are other UK sourced products that have that status, Cornish pasties, Melton Mowbray steak pies. Not as much healthy food actually, now that I think about it. And equally they apply all over Europe as well. So, you know, all the DOC cheeses and wines and things that you can get from all over Europe have this protection. And the idea of it is not where maybe with a trademark or something, it's about, you know, protecting the distinctiveness of somebody's brand or business and allowing them to make sure the public aren't confused. Here it's about, yes, making sure the public aren't confused, but doing that by protecting the provenance of something. And so you can only actually have the geographical indicator, if you can establish the association with the place and the quality of the place, and then there is a legal regime that will protect that. And that until now has operated EU wide, which has been very helpful for those manufacturers of or producers of items that are then distributed EU wide. That's going to be broken up too. Now, this is one of the relatively few issues here where it is still up for negotiation. It has not yet been concluded as part of the trade deal to what extent this will actually be bottomed out, and the proposals that the UK government has put forward are on the assumption that that can actually be agreed. And so what we will replace the existing EU regime with is a UK specific one, which will recognise I suppose these geographical indicators within the UK. And now that is probably going to be slightly less useful than having that done on a UK-wide basis. Certainly, insofar as it affects UK consumers, it would potentially create more scope to not necessarily create fake or impersonations of UK sourced geographically protected products, but possibly EU wide ones, because those rights wouldn't be as directly enforceable. And there is some discussion, because I think it is recognised that that might not actually be in the interests of consumers either here or in Europe. That is currently being looked at and being negotiated. So the final position that we land on that might not be absolutely certain yet. That's probably true of a lot of this, but I would have less confidence that we know where this is going to end up than almost anything else that we're talking about here. And so that brings me on to data, and this, in many ways, this is probably the most directly affected area, because almost all of our law on data protection is directly derived from EU regulations, and even the bits of the law that apply only to the UK are really where we've filled in the gaps. So GDPR had certain areas where they simply couldn't agree how to deal with it, or they didn't address it at an EU level, and it was left for local or member states to frame their own provisions. And an example of that would be processing of criminal records information and the like, where most of the provisions that regulate processing of that are set out in the Data Protection Act 2018. Things like the ability to justify certain types of processing on the basis of substantial public interest. It was left to individual member states to define what they meant by a substantial public interest and what they would regard that as covering. So that'll be slightly different in each member state. But the guts of it applies European-wide, and is also an area where in the process of formulating the GDPR, there were quite considerable differences between the UK government and Brussels, and where going forward there probably is some political appetite to look at whether the balance of the regulatory burden posed by data protection laws in the right place, and certainly some political pressure here and there to suggest that ought to be alleviated. There's concern in particular, and this is maybe one area where we will see the sharp end of this quite soon, that things like the extraterritorial provisions of GDPR, the extent to which it regulates overseas data processing or allows the sharing of data internationally, is potentially just not reflective of how the modern world works, and the difficulties that they've had in coming up with appropriate ways of controlling and regulating, for example, data sharing with the US has been quite problematic. We've had the Safe Harbour and the Privacy Shield and the Schrems case in the last little while, and there's still not really a kind of clearly established and easy way to do all of that. So this is an area where there could be some change in the future. One of the things to be aware of, and that people aren't always necessarily, I guess, identify with straight away, is that actually the concept of processing data is a very broad one. A lot of people tend to assume that where their data is processed is where it physically sits on a server. So that could be, in their office environment, in a data center. If it's in the cloud, it's in someone else's data center, and you may or may not know precisely where that happens to be. but actually, the definition of processing data legally is much wider than that, and effectively almost any place where your data can be accessed is a place where you are processing data. So if you are on holiday in India and you can access your work email systems, or if you have any outsourced or offshored operations in any of those territories, and potentially the data is held in the UK but accessible to agents outside the UK, that's processing data outside the UK, potentially outside the EEA too. So actually, what constitutes processing data is wider than is commonly thought. Doing almost anything with data, even storing data at rest, and hardly ever looking at it, is still processing data. So that will have a wider effect than some people assume. And sometimes when we get asked to look at whether there are issues with the way some data has been handled, just understanding what the scope of the data processing is can come as a bit of a surprise to some of our clients the first time they look at it. The other thing then is to think about, okay, once you know where your data has been processed, what do you need to do with it? Where does it need to go? Is that a necessary use of data? Is it optional? Is it optional but highly commercially advantageous? And thinking through what you want to do with your data is then a key aspect of it. And then you can think about how you then put appropriate controls and processes in place to allow you to do that and to maximise the use that you can make of your data while still complying with the rules. And in doing that, you have to think about responsibilities that you have in the case of customers or data subjects. The key areas where people are most sensitive, and to be fair, rightly so, because the areas that get the most regulatory attention tend to be the more aggressive or intrusive forms of direct marketing, and also security and liability for data loss. And these are the areas where you generally find organisations are being scrutinised most closely, and where regulatory fines are being imposed. And one of the ways that I suppose inadvertently exporting or transmitting data outside of the UK or the EEA is that the perception or the policy behind the EU law is that a lot of these territories will have significantly less robust protective regimes than we do, and so by doing that, you're effectively taking them outside of the protective ambit of EU law, and there are barriers and challenges put in place to doing that. There are various ways you can deal with those. And we have a lot of businesses that we're working with at the moment who may, for example, have supply relationships or service agreements or the like with clients and customers in the EEA who are going to have to continue that going forward. And in some cases, they're being pressed by their customers, to demonstrate what are you going to do to safeguard our data once you are outside the EEA, because that is something that then requires special attention under the GDPR. The most obvious way and the easiest way to do it is to agree and sign up to standard contractual clauses, and that's effectively an EU sanctioned document that would require you in processing data to comply with EU data protection laws. Now, at the moment, they apply directly to most businesses anyway, and any business that is currently compliant with GDPR, and I appreciate that not every business is necessarily absolutely 100% compliant, but most by now have had a decent go at trying to make sure that they are. So if you think you're compliant with GDPR, it shouldn't in theory be significantly increasing your burden to agree to standard contractual clauses in the form they currently are. You can't fiddle about with them, you more or less have to paste them in exactly in their current form. And use them. The big advantage of those is that there is no regulatory sanction or approval needed to use standard contractual clauses. You can literally just paste them into an agreement or put in an amendment in place to cover it, narrate the details of the data processing that you're carrying on, commit to the standards that they require of you, which are basically to comply with the current rules, and you'll largely be compliant. The alternatives tend to be a lot more cumbersome. You can have things like binding corporate rules, which is effectively where you have a regulator sanctioned set of policies that you will apply. For example, if you operate a group of companies with subsidiaries in different EU territories and potentially some outside those territories, that's commonly something that's done, but there's a lot of work involved in that, and there's the challenge of making sure that they are approved by a regulator. So we have seen them tend to be used relatively infrequently, and generally by very large organisations who will have a probably information management or data protection officer resource in more than one territory. There are some administrative things that public bodies can do in relation to that, and then there is a list of special derogations and exceptions, but these tend to be very limited. They can't generally be used for processing on a routine basis, albeit one of them is individual consent, but that is subject to some additional requirements around disclosure of the risks and the transparency of the arrangements and everything else. And this whole area of exporting data and working out the circumstances in which you can lawfully export data or use it somewhere else is actually, even without Brexit, is one of the most difficult bits of GDPR to advise clients through, because it very readily throws up outcomes that just don't seem to make common sense, or which potentially get in the way of what really ought to be relatively low risk, non-intrusive processing of information. And so there is a risk, I think, that some of these outcomes and conclusions might arise in dealing with commercial partners, customers, or companies you're doing business with in the EEA, particularly if they have a risk-averse or very cautious approach to their own data protection compliance. And you tend to see that in some countries more than others. A lot of EU law and a lot of the importance of privacy has very much been influenced by both human rights law and also public policy in Germany over the years. And you tend to find that certainly dealing with a lot of large organisations in Germany, they are very culturally resistant to taking a risky approach or a high risk tolerance towards data processing issues. And so we do anticipate that there might be some challenges for businesses in trying to work with cross-border data flows, unless you're able very readily to adopt the standard contractual clauses. They are actually due for an update quite soon as well. The existing version of the contractual clauses, in fact, doesn't even post-date GDPR. They were drafted under the old Data Protection Directive framework and are in the process of being updated and sanctioned. So they might change before too long. But if you're doing business on a regular basis with customers in the EU, then that is probably the easiest and most workable basis to use, particularly if you need even to regulate transfers within a group of companies. If you've got subsidiaries, or if you've thought about setting up affiliate companies in territories like Ireland or the Netherlands and the like, then it may be that you need to just put that in place so that your internal governance covers you and allows you to move information in and out of the EEA. In the longer term, it's probable that the EU will make a lot of this go away by issuing an adequacy decision, and that's a process where effectively the Commission can look at the level of data protection offered by a legal system and conclude that there's enough there to say that it's a safe place to process data. And to date, that has been used in relatively limited territories. It's been used in places like the Channel Islands and the like. They haven't generally sanctioned an economy of the size of the UK or reached an adequacy decision to that extent. I mean, in theory, if there's no intention to rewrite and start ripping up data protection law straight away, that ought to be a really straightforward thing, because in practice we will be applying the same rules on the 1st of January as we applied on the 31st of December. There is, of course, a strand of opinion within the government, which is that we shouldn't be giving any commitment going forward as to what form our rules will take or anything else. And if that manages to avoid engagement with Planet Earth for that long, it will make getting an adequacy decision or something quite difficult. But it ought to be a way through this in probably 6 to 12 months, I would have thought, unless there is a real political disharmony between the UK and EU governments. But that is definitely possible, depending on what happens. So from a risk management point of view, it's probably important at this stage, and one of the things you can do in preparation would be to look at whether your privacy policies in terms of how you manage information, the notices that you give to people when you collect information, deal with any cross-border data flows that you may need to implement, and that you look at whether, if you've done things like data protection impact assessments or registers of processing activities, they reflect the change in circumstances, that you may now have some data importing and exporting going on that in the past you didn't really have to worry about if it was all taking place within the EU, and have answers, I guess, for customers and people you're dealing with as to how you would address and resolve these issues. Especially if it's anything other than the standard contractual clauses, which, as I say again, is the easiest one. And these are things that a lot of businesses are thinking about at the moment, and we're negotiating various amendment agreements and updates to contracts to try and reflect a lot of this into arrangements going forward in terms of ongoing software and SaaS services and things that clients of ours are providing to organisations across the EEA, and it's unlikely to completely escape you if that's what you're doing. There is also the regulatory regime in GDPR itself has a concept of lead supervisory authorities, and it's possible that if you are processing data in more than one EU member state, that there needs to be a process of identifying who it is that actually regulates you. And the idea here is that effectively the equivalents of the ICO in different EU member states do not all double up and regulate a business doing business cross-border. Rather, you would have one regulator, because the law is basically the same anyway, that would apply. So what may happen post-Brexit as well is that some organisations, depending on their processing activities, will have to get to know and be familiar with the direction of an EU data processing regulator, as well as the ICO that we have here. And although the law is the same, the way a lot of them enforce and approach the rules that they're charged with managing can differ a bit. So that may be something, possibly not for everybody, but certainly it might affect some businesses. Lastly, the requirement to appoint a data protection officer will remain post January the 1st. The requirement to have a data protection officer in GDPR applies where your processing is of a certain nature, or where your organisation is of a certain nature, like if it's a public body or if it's processing data of a certain volume and complexity. It's interesting because this is one part of GDPR the UK government was very opposed to, and it's one of the features of GDPR that people who believe GDPR is an overly intrusive regulation think ought to be pared back. But at the moment that regulation remains in place. There's no immediate desire to change it, and there would be a requirement that a DPO have expert knowledge of UK and EU data protection law if you're going to be continuing to operate across the EU, and that the DPO that you would have would be accessible to any UK-based data processing operations and EU ones if that's happening. In the short term, it's probably not a practical issue for people that have those persons or those appointees in place. Going forward, if the rules diverge, it might become more of a challenge for privacy managers to keep on top of both. But that's not a requirement that's going to go away immediately, and there's not necessarily any great appetite, I think certainly in mainstream government opinion, to see these things change. But it was one of the very visible, I suppose, requirements of GDPR that organisations had to take account of. So in terms of just drawing this to a conclusion, I'm sorry, I appreciate I've maybe spent a bit longer talking about this than you had expected. The key things I think that we would flag are that it's probably important to look at identifying what intellectual assets your business is using that are deployed or may need to be protected across the EU. What have you got there? What have you got registered, or might you think about registering in future? If you were interested in registering a EU-wide trademark, you've got basically between now and the 31st of December to do that. In some cases, looking at where you potentially have territorial and geographic restrictions or licensing provisions and contracts, and how these will be affected by a departure from the EU. Speak to the people that you do business with in the EU and get a feel for how they how they perceive things are going, or where they think they may need to look at their relationships either with you or with others, and try and, I suppose, get any early warning of any concerns, but also make sure that you're actively managing those relationships. It's interesting how bizarre the perceptions are of how the UK is currently being run across Europe. If you make small talk with almost anybody who's doing business in another EU market at the moment, they've got all sorts of ideas about what life is like over here, and not, it must be said, universally favourable impressions of the British government. And so maintaining those relationships, you know, at a corporate level is going to be important. Potentially being able to reassure or correct any significant misconceptions that your EU partners and suppliers may have about how the UK economy is doing, or what your future relationship and how your business dealings are going to develop going forward. And also look at the data issues, and look at whether, you know, are the assumptions you've made about where you need to process data, where you send data, where your data's been held, are they correct, and are you able to manage those, or do you need to potentially look at making any adjustments? There is a limited window to do that pre the end of the transition period, but in practice, while there are a lot of, to use a Donald Rumsfeld term, known unknowns out there, there are some things that can be looked at and that can be planned for just now, albeit we do not have anything like the level of certainty that certainly most businesses we talk to would like to see at the moment. The other thing I would say is have a word with your accountants. If you are dependent on certain tax treatments of certain types of transactions that you make, some of that is changing. It's not within the scope of this talk. Being a mere lawyer, I can't give you advice on your tax arrangements, but it is something that's potentially subject to quite significant change, particularly if the trade talks are not necessarily successful in terms of leading to a deal. And so that I guess would really be all I would have to say at the moment. If there is anything, I'm happy to take some questions in the time we've got left. Alternatively, if there's anything that you want to ask or reach out to us with, my contact details are there, and please feel free to get in touch. But I'm happy to hand over the floor to any questions we have at the moment.
Brilliant, thank you so much, Liam. Now there are definitely a couple of questions. I think what I might do is just invite the folk that kind of put them forward to come in, and just in case they had anything supplementary. Douglas, just because yours was in first, if you would like to unmute. I don't think we covered that question, but if you can, do you want to unmute and just come in and ask?
Sure, yeah. Can you hear me okay?
Yes.
Yes. So just really when you were talking about the GDPR stuff earlier on in the presentation, just a thought that came to my mind was on employment contracts that might be referencing GDPR clauses, I guess, from 2 or 3 years back. Would that have been referencing EU GDPR clauses, and would they need to be revised in employment contracts, or what are your thoughts on that point?
One of the things that's going to happen in relation to the transition arrangements is that references to EU terminology and EU law will still be recognised. Some of them will be subject to certain adaptations, but I mean, if you had employment clauses in your contracts that specifically referenced GDPR, or that specifically referenced data processing activities that you would have to carry on as an employer because you were bound to under GDPR, those will in the main probably still be relevant. The other thing is anything in an employment context that relates to, for example, criminal record checking or the like, would be generally subject to regulation at a UK level anyway. So they won't be instantly rendered obsolete, but they will in due course probably need to be updated, and particularly if the law changes in the UK, then that's something that we would have to look at.
Great,
thank you.
Thanks, Douglas. Shona Hamnet, you asked a couple of things, or there was, I think, an observation probably more than anything, and then a question. Do you want to come in and just ask anything in specific terms?
Yeah, obviously, thanks, Alison. I was under the impression that obviously the government would be looking to adhere to the EU GDPR, but I didn't know if I'd picked that up wrong. just because of the fact that we do so much business as the UK and didn't want that to end. So have I picked that up wrong?
I would slightly hesitate to express a firmly confident view in what the UK government does favour and doesn't favour from one day to the next. To be honest, I think it would be fair to say there isn't any immediate desire to change the provisions of GDPR. I think there's a recognition that there's probably a limited appetite for disruption that most people have to changing any of that. And certainly the legislation that's been put in place at the moment is likely to, well, it will continue. It's effectively incorporated the GDPR into UK law, and on the 1st of January that will remain the case. There are certainly for individual backbenchers and the like within the Conservative Party who think that there is a lot of GDPR that represents unnecessary red tape. What the UK government was not in favour of the requirement to appoint data protection officers at the point GDPR was being formulated. I mean, there's been a lot of commentary, not just in relation to GDPR, but kind of anecdotally about various aspects of European regulation. It would be great for global trading free Britain to cast off. When it comes to the specific examples of what they would actually change, there's much less of it. And I think there's some people grumble with GDPR. And to be honest, advising businesses day in, day out on GDPR, I can understand why some people would want to grumble about GDPR. I don't think in the very short term there's going to be any desire to start ripping that up or changing it. But going forward, any decisions about that, some of the policy issues related to that will be determined exclusively in the UK. The other area where that might be affected is that it's highly likely that the UK would probably be susceptible to more influence and pressure from the US than the EU would be going forward. And there is a recognition that privacy law has to be taken seriously, and that data subjects' rights have to be respected. In the US, there are quite a divergence of views within the US as to how that should be done, and there's not generally a great deal of enthusiasm within the US for the way that the EU has chosen to do it in relation to GDPR. So I think you may well see some wrangling over that, but I don't think you're going to be hit with any immediate surprises in the first 6 months of next year or anything like that.
That's great then. Well, that kind of brings me on to my second, well, the question that I was going to ask, because obviously we had concentrated on the data processing and the protection and mainly UK, but because we all use social platforms and media platforms, a lot of them aren't UK based. So what would you suggest for the data processing and protection? What, update your policies, or can you advise of anything else?
Well, it depends where they're. I mean, to some extent, actually, if they're based outside the EEA already, like Facebook, for example, and the like, then it might not actually change that much, because if they're based in the US, then that would already be activity that's been processed outside the EEA. If you're using, actually, most of the major platforms tend to be set up like that. I mean, if you're using, one of the things that GDPR has required a lot of businesses to do in their privacy policies is give a lot more granular detail about how exactly they're processing data. And one of the things that you typically have to address is whether you send data outside the EEA or not. So I suppose if you were a business processing data within the EEA subject to the European rules, and then as a consequence of Brexit, you're not anymore, then that's probably something that would have to be addressed in an update of your privacy policy. But if you're exporting data to the US today, and you're going to be exporting data to the US on the 1st of January next year, legally, I'm not sure that necessarily changes a great deal.
No, thanks for that. It was more to the fact that I'd never even considered that we use that as a data processing platform, to be fair. So you actually highlighted something that made me think about it.
I mean, the other thing to bear in mind is you have to look, if you're talking about something like Facebook, you have to look at who actually holds the data and where the data is actually being processed. But there are a few risks with that. So, for example, a lot of the Facebook advertising products and things like that are based on the idea that they will punt out your content to users that fit certain metrics or that tick certain boxes, whether it's based on location or interests or age or anything else. you don't ever necessarily even see the data or know who these things are being sent out to. And there is European case law that says even in those situations you are controlling and directing data being processed in certain ways, even though you never actually have a copy of it. So there are risk issues. That it's not a coincidence that most of the major social media platforms originate from the US, where there is far more freedom to frankly mess about people's personal information than is the case in the EU. And some of them, the biggest challenges for the likes of Facebook and have come with making their businesses GDPR compliant, or trying to make their businesses GDPR compliant. There's quite a large school of thought they haven't done it. So you would have to look at what data you're using and what you're doing with it, because you might find that you're potentially on the hook legally for what you actually think somebody's doing on your behalf with data you never see or touch, and you can still have some responsibility for it.
That's great, thank you.
Perfect, thank you, Shona. And just one last thing then, John Cargill's got a question about product standards. John, do you want to come in?
Yes, please. Thank you, Alison. Good evening, Liam. Thanks for steering around IP and data. Does your remit include advice around BSI product standards and CE marks as distinct from just trademarks, or is that a whole other item?
It's a different legal area, because trademarks are more about mapping the distinctiveness of who's selling goods and where they're coming from. BSI standards and CE marks are more about the regulatory standards in terms of safety, freedom from harmful materials and things that are used in the manufacture of goods. And that is, I believe, one of the key issues at stake in the open negotiations in terms of the level playing field, and how lax those standards might be allowed to become in the UK versus in the EU. Generally, when we look at that, it does tend to have to be quite a granular level, I believe, because they tend to vary quite a lot for different types of products and classes of goods.
Yes, it's almost item by item in some cases.
But that is an area. I mean, that is one area where I believe effectively it remains one of the last issues and one of the trickiest issues, I think, to resolve in terms, because that is effectively part of the level playing field. If you have a situation where you effectively render goods lawful to be sold in one territory but not in another, then that directly is going to affect the competition and the trading dynamic across those two territories. And I think there is quite a lot of pressure to try and keep those harmonised. And the other thing is, I mean, in a lot of cases, some of these requirements are really just kind of manufacturing, engineering, common sense, and unlikely to be controversial anyway. But in areas where there is potentially a degree of judgment involved, there is a bit of wrangling going on, as I understand it, about how much the UK should remain free to make its own determinations around things like that.
Okay, thank you.
Thank you, John. Liam, thank you so much. A huge amount of information. It's just, I think we just talked, and I'm sure you do talk to a lot of businesses that do say, oh, well, we've thought about it a bit, but we're waiting to kind of hear the detail. But it's clear that people really shouldn't and can't afford to be doing that. And I think we got an awful lot of information from you there, and I think we've all probably picked up a few things that we're now going, okay. So thank you. I just wanted to kind of finish off, because I'm conscious of time, but I just wanted to highlight, so I'm not going to pick on Vince from our international team. I said I might pick on him to come in, but it's come up in our previous sessions where we've particularly been talking about things like our Chamber Customs product that just launched, which is about us helping businesses with customs declarations, and there's a whole bunch of other support, I think, that not everybody's always aware that the Chamber offers. So one thing that I'd like to just highlight to everybody, whether you're watching this on YouTube or whether you're with us tonight, is that the Chamber's got a Brexit hub, and we look to just keep that as up to date as possible. It's not got the every single level of detail, but lots of signposting. So we've got access to lots of places that you can get information, but not just that, but partners and local experts like Liam at Thornton's, and the Institute of Exporters when it comes to logistics, or we've got the British Chamber Network, and a really wide range of chambers of commerce that have been doing international trading and support for an awful long time, plus Scottish Enterprise and SDI and our kind of partners all across Scotland. So we don't know all the answers, but we certainly have got access to get you a lot of information, and we are talking more and more. I think our team had really quite a long conversation with a local manufacturer this week, and we're able to answer some questions and kind of put them in touch with some people that can really help. So thank you, Liam, and I think it's time for us to kind of, I think, wrap up this evening, but it's been a really good series. There's an awful lot more, I think, coming down the line in terms of Brexit, but it feels like we've been talking about it for a long time too. So thank you, Liam, for your time. Thank you to Sarah for getting us all organised, and thank you to those of you that turned in to kind of have a bit of a chat with Liam in person, and those of you that are watching it on YouTube. So until the next time, I would just say, look out for some more social events coming before Christmas time. Sarah will keep you up to date on that, but we are planning lots of things like We Cook Pie cook-alongs and all sorts of other stuff. So Liam, thanks again for your time, hugely appreciate it.
You're welcome.
And we'll catch up with everybody at another session. So thank you.
Thanks, bye-bye.
Thanks, Liam.